Thank you very much for your attendance today. Welcome to the latest disputes resolution seminar hosted by Watson Farley Williams. My name is Sumeet Malhotra, and I'm a partner with the dispute resolution group at WFW in Singapore. Before we get started and before I introduce myself and my team properly to all of you, there's a little bit of housekeeping that I've been asked to go through. And very briefly, just for your information, all microphones and video devices have been disabled and will remain disabled for the duration of the webinar. The webinar will last no longer than 1 hour and is being recorded. Questions are encouraged and will be answered at the end of today's webinar. Questions can be submitted using the Q&A function. If we do not have time today to answer your questions, we make it a point to follow up with you personally so that we can address any questions that you have that we weren't able to address during the course of the webinar today. Now, with that, if you will, please allow me to again properly introduce myself. I'm a partner with the disputes group at Watson Farley. I manage a team of roughly 10 to 15 fee earners across various geographies. And our team happens to be headquartered in Singapore, and some of the members of the team are here in the room with us today. Each of the members of this team has dealt with matters that are similar to the matter that's under discussion today. And so I'm looking forward to a bit of vibrant discussion. And again, as we said earlier, we welcome your questions. As regards the topic itself, we're talking today about circular trades or structured commodity trades, a topic that has generated a great deal of controversy in recent years. And finally, the Singapore High Court has shed some light and provided clarity on what the true nature of these transactions is. Alankriti, during the course of our preparation for today's webinar, you would ask me a couple of very pointed questions when we did a dry run earlier today.
Yeah.
I think those questions are excellent and they set a great deal of context for today's discussion. And so, Alankriti, can I invite you to ask those questions to me for the benefit of this audience?
Sure. Hi, everyone. So I think the first question, and it's quite introductory, but why is this topic important?
Why is this topic important? Thank you for that, Alankriti. The reason why this topic is important is because ever since the commencement of the COVID crisis, in the aftermath of a number of commodity trade defaults and the volatility within the commodity industry that has resulted in a number of disputes, these trades that are under examination today, circular or structured trades, have acquired a fairly pejorative reputation. They've been couched as sham transactions, and a narrative has been created around these to suit the needs of people that are resisting claims, to suit the needs of players that are resisting claims that have been made by commodity traders. There is a case now that has been decided upon by the Singapore High Court that finally sheds light on what the true nature of these transactions is and finally provides clarity. It is important that we broadcast the lessons that arise out of this case because it's important for the commodity industry and all of the participants in that industry, including underwriters and lenders, to understand what the takeaways of that case are and hence why this topic is important.
Okay, thank you. I want to ask the second question, which is, so I appreciate that this is a case study, and you just mentioned that there has been a case that has been decided by the Singapore High Court. But you have not, and I also note that the invite that was circulated to the participants did not mention the identity of the parties. So could you elaborate on why that is?
Why the secrecy? Why haven't we named the parties to this case? This is, after all, a case update for this audience, but you'll have noticed, Alankriti very well picked up that in the invite, we didn't name the case. Nor have I made any reference to it in the introductory remarks to this webinar. Now, there's a good reason for that, and I'm really glad you asked this question. The reason why we've been restrained about naming the parties to the case, now look, it's very easy to sensationalize a case in the realm of disputes. Oh, one party lost, one party won. Look at that. Let's now name and shame the losing party. Let's celebrate the victors. Now, what that does, Alankriti, is it creates an adversarial discourse. It creates an environment of us versus them. And that is a discourse that has been led in this industry for the last 2 years. And I've seen that unfold with a great deal of dismay. When the crisis first began, there was a narrative that was led by the underwriters and the banks, and who can blame them? They wanted to resist claims at the outset, and they ran a narrative that all commodity traders are engaging in fraudulent sham transactions. And because of the fraudulent and sham nature of these transactions, we, the underwriters, or we, the lenders, shouldn't be required to pay those commodity traders. Now, that's a really dangerous narrative to run. And we could have couched today's webinar along the lines of that same adversarial narrative. We could have celebrated the fact that we act for commodity traders, and it was a commodity trader that won this case. We could have celebrated that, and we could have vilified the bank, stating that the bank led spurious arguments, which the court has then held as spurious. Now, what's the point of that? The fact is that the commodity traders can't trade unless they have bank funding, because they need liquidity to trade. Commodity traders can't trade unless they have underwriters willing to underwrite trade credit risks. Similarly, banks have made billions of dollars in commissions on international trade. Underwriters have made billions of dollars in premiums on the basis of underwriting trade credit insurance. The fact is that the commodity trading houses, the lenders, and the underwriters are all part of the same international commodity trading system. And to run an adversarial discourse is, in my view, short-sighted, disingenuous, and frankly immature. And hence, ladies and gentlemen, we will be discreet about the parties involved in this case, but we will enlighten you on the principles set out by the court. And it won't be our endeavor to name and shame the parties, but rather to leave the audience with what the lessons are, what they can learn from this case, and how they can better protect themselves when exposed to structured trades in the future. Alankruti, does that answer your question?
Yes, that does. I also wanted to just throw it out there, but what about Hin Leong, Agritrade, Phoenix? What about these sagas?
Okay, so we've talked about, I'm very impressed at this probing line of questions, Alankruti. We have to acknowledge, we've just talked about how the underwriters of the banks and the commodity trading houses are a part of the global commodity system, and there's no point in us taking adversarial positions against each other. We all need to learn how to work together. But you made a valid point. You say that, look, we can't run away from the fact that Hin Leong, Agritrade, and Phoenix behaved quite shamelessly, and indeed shamefully, and engaged in frauds on a massive, massive scale. Yes, this industry has been beset by some bad behavior perpetrated by the commodity trading principles. There can be no doubt about that. But in light of these sagas, Agritrade, Hin Leong, and Phoenix, to paint the entire industry with that same black brush is the equivalent of accusing Mickey Mouse of inappropriate conduct simply because he's in showbiz and so is Harvey Weinstein. You'll appreciate that that's a fairly reductive and a fairly disingenuous leap of logic to make.
Yeah.
Just because Agritrade, Hin Leong, and Phoenix engaged in commodity trade frauds doesn't mean that the entire industry is composed of fraudsters.
Yeah.
And so, again, it's a dangerous narrative, that adversarial narrative. While I do acknowledge that, yes, there have been instances where people have engaged in disappointing conduct, which industry hasn't been beset by scandal? And just because an industry is beset by some scandals, it doesn't tar the entire industry. We must acknowledge, Alankruti, and this audience, that commodity trading houses perform an invaluable service to mankind. Commodity trading houses connect areas of surplus to areas of deficit and smoothen out global imbalances in the supply of goods. The knock-on effect of the activity that they engage in, and this is the notoriously dangerous activity from a profitability perspective, but they nevertheless engage in this activity and have a vastly positive effect upon the quality of life of people. Now, the minute you engage in an adversarial discourse and you start painting one party as the villain, what happens? And we saw this happen. What happened was, in the aftermath of these scandals that you just named, a number of trade credit underwriters left the industry and a number of banks fled the space. What that resulted in was a contraction in liquidity that was available to these traders. And what that resulted in was the fact that these traders couldn't trade anymore, which means that areas of deficit now suffered from imbalances and they could not receive the goods that they needed in order to be able to preserve the quality of life of the people that inhabit those areas. So we need to acknowledge that this adversarial discourse has a massively negative effect on the day-to-day quality of lives of people. And it's about time this discourse ended. With that context set, perhaps I should talk a little bit about the case under discussion. And I'll describe the facts of the case very briefly. Now, the case is complex. It is very, very fact specific. And there are a number of lessons that come out of the case. But for the purposes of this webinar, I will focus only upon what the court commented on in relation to the nature of structured or circular trades. I will not talk about some of the other aspects of this case that the court touched upon and the additional guidance that it provided. But if you'd like a comprehensive review of what the fallout of this case is, we will follow up with you for feedback after the webinar, and you should please send us questions directly, and we'll be more than happy to answer them. If there's sufficient interest with the audience, we're more than happy to schedule a further webinar in due course to talk in more detail about the fallout of this case. But very briefly, this case arises out of a transaction in which a bank funded and arranged for the issuance of a letter of credit for the purchase of certain goods. So there was a trader that was purchasing goods from another trader, and the buyer in that case was the beneficiary of a letter. The seller was the beneficiary of a letter of credit that was arranged by the buyer. So the bank issues this letter of credit, but what the bank does not realize, and it's never told to the bank, is that the original trader who sold the goods to the buyer then repurchased the goods. And so trader A sells to trader B arranges a letter of credit, and then trader B resells the goods back to trader A. Now this is where the bank objected, and we'll talk about the bank's objections, but let's talk about the facts. So you have the sale transaction. As it turns out, trader B in this case was one of those illustrious fraudsters that Alankati has already spoken about. It was Hin Leong. And Hin Leong's disappointing conduct is now the source of legend within our industry. So what happened was the trader sold these goods to Hin Leong. Hin Leong arranged an LC. The LC issuing bank duly issued the LC, and then the seller of the goods, who was selling the goods to Hin Leong, claimed under the LC. They submitted compliant documents and they received monies under the LC to the tune of about $37 million in change. Immediately, those goods were sold back to the original trader. Yeah, let's park that fact for a moment. When it came time for Hin Leong to pay the bank eventually, Hin Leong was already in liquidation and the bank could not recover its money from Hin Leong. And so the bank was left with no recourse. And now this is an understandably disappointing outcome for the bank. If I were the lender in this case, if I'd arranged that letter of credit, I'd be upset as well. I'd want my money from somewhere. And so the bank then looked to the trader and said, hang on a second. You sold these goods to Hin Leong and then immediately bought them back. That's a sham transaction. That's a fraudulent transaction. Clearly, there was no intention to engage in genuine trade here. The only reason you entered into this transaction was to provide inventory financing to Hin Leong. And had we known that that was the true nature of the transaction, this was a financing transaction, we would never have participated in it. Therefore, you, the trader, have conspired with Hin Leong to defraud us, to engage in a sham transaction, and you have therefore unjustly enriched yourself by reason of receiving payment from us. And we, sir, would like that payment back from you. And so they sued the trader. This matter went to court, and the court has held that in the event the transaction was not a sham transaction. And I will talk in some detail about the rationale that the court applied. But before I do that, let me just take a step back and give the audience a bit of context. Now, I was very interested to see the attendance list at the webinar today, and we've got amongst the attendees commodity trading principals, we've got lenders, And we've got a number of insurance brokers that I presume are engaged in the business of broking trade credit insurance. I'm not sure if we have any underwriters on the call today, but there may well have been some new joiners between when I last checked the attendance. So essentially, the audience today is represented by stakeholders that are all affected by this case and are parties of the type of the parties involved in the case. Now, everyone in the audience is an experienced participant in the commodities industry, and everyone will know. And if there's anyone that disagrees with me, you should please make a remark in the questions and we'll air that later. These transactions, these so-called circular transactions where party A sells goods to party B and then buys them back, we all know that these transactions are ubiquitous in our industry. I have been dealing with these sorts of transactions in various capacities, either as an in-house lawyer, as a structurer of these transactions, again, in-house at a major commodities trading house, or as an external lawyer for the purposes of either defending them or enforcing them for the last quarter of a century or so, ever since I commenced my career in this profession. And by the time I joined the profession, these transactions, as I have said, were ubiquitous. And so for anyone in this day and age, in the year 2022, to say that I am a trade credit underwriter or I am a trade credit lender, but I view these contracts with suspicion is rather rich and disingenuous. These transactions have been around since time immemorial. And as long as there's been credit, these transactions have been structured and strung in this way. And so it's rather belated and a bit of an afterthought for anyone to now start questioning the legitimacy of these transactions. But you know what? A number of banks and underwriters were faced with defaults a few years ago, and they were desperate for a solution. And one of the solutions that was offered to them was, look, let's question these transactions on the basis that they're sham transactions. Because after all, why would you, a trader, dispose of goods and then buy them back? That seems suspicious at first blush. Now, indeed, it does seem suspicious, but anyone who's spent even a minute in the world of commodity trading knows that these transactions are incredibly common, and there's any number of rationales for transactions of this nature. One rationale could be that the market simply moved and you wanted the goods back because you took a view on the market and you said that, okay, I've shorted out my position, but I've taken a view on the market and I'd like to get this inventory back onto my books because the market's heading back up. Alternatively, you may have entered into the transaction simply as an inventory management solution for one of your clients who wanted to take that inventory off their balance sheet, however temporarily. Or it could be that you entered into that transaction as a form of trade finance for your counterparties. Now, this last bit is where the controversy has arisen in recent years, where underwriters and banks have said that, hang on a second, this wasn't a genuine trading transaction. You entered into this transaction for the purpose of providing funding or credit to your buyer. And had I known that, I would not have underwritten this transaction or I would not have financed this transaction. Now, in this case, crucially, and this is the sole aspect that we're going to focus on during the course of this webinar, is that the court has unequivocally, and this is the special bench of the Singapore High Court, is that correct? There you go, a very august bench of judges has held that this is not a sham transaction. And I'm going to quickly read out just one line that sets out part of this decision. It's a really, really interesting observation made by the court, where the court says that the motive for a transaction is not in and as of itself determinative that the transaction is a sham. Let's just go over that again. The motive of the transaction is not the sole determinant of whether the transaction is a genuine transaction or not. Ergo, if the transaction was with the motive of providing financing, that does not make it a sham trading transaction. In order for the transaction to be defined as a sham, it should be one where the parties had a common intention to create a pretense of a transaction in order to deceive others. And as long as the documentation appears genuine and that there is no evidence that the parties did not intend the rights and obligations to be real ones, the transaction would not be a sham. Let's just quickly revise that. Courts held that the intent behind why a transaction was structured is not determinative of whether the transaction is genuine or not. What is determinative is whether the parties colluded to deceive another party and whether or not they had a real intention of trading in goods. In this case, the court held that there was a genuine intent to trade. There were real goods that were shipped on board a carrying vessel, they were carried to the discharge port, and the fact that they were not delivered to the buyer, but rather to another party down the trading chain, does not make it any less authentic. The court furthermore held that the fact that the trader did not have custody of the original bills of lading, again, not determinative. Copy bills of lading are, again, ubiquitous, particularly in short sea trades. A lot was made of, in this particular case, of the fact that original bills of lading were no longer in the custody of the trader. Again, the court said that that's not relevant. Parties trade without exchanging bills of lading all the time. Parties trade without engaging in physical delivery of the goods all the time. Just because I've sold the goods to Aditi, and Aditi then sold the goods on to Alankriti, and Alankriti then sold the goods on to somebody else, and they finally get delivered to an end buyer, does not mean that our transaction was anything less than genuine. In doing so, what has the court done? In doing so, all the court has done is to identify what existing trading, international trade practice is, and to state effectively that the way international trade is practiced at the moment is nothing short of genuine, unless there is a proven intent on the part of the parties to deceive another party. Now, as long as that intent doesn't exist to deceive, these transactions are not sham transactions and they are genuine. Now, this is really, for me, the big takeaway from this, that a circular trade, and there's been so much written about this in the last few years, about how all of the trading houses are engaging in these financing transactions, and these trades are circular in nature, they're in the nature of repos, and therefore there's no intention to trade. All of that discourse has been swept off the table by the court neatly, and the court has said, no. There's nothing untoward about these transactions. They're clearly ubiquitous. And as long as, in this particular case, there was a case involving an LC, but I will talk about cases involving insurance policies as well, and I'll also talk about cases involving discounting of LCs. In this particular case, the court has held that, look, as long as the beneficiary submitted compliant documents, you, the bank, were bound to pay the beneficiary. You, the bank, were bound to pay the trader. And once the traders submitted those compliant documents and it's taken the money, you don't have any more recourse against the trader. Your recourse lies against the applicant of that letter of credit under the LC facility agreement. And yes, we acknowledge that that applicant is now insolvent. However, you know what? You, the bank, did your due diligence. You did your credit checks on that obligor, and you were satisfied to run that risk. And so now, this late in the day, to go hunting for a party that has deep pockets and that may be able to respond to your claim is disingenuous and an afterthought and should not be encouraged. And so that, to me, ladies and gentlemen, is the sum and substance of this particular case. Now, what does this mean for industry participants? There are certain takeaways that we all need to absorb in relation to this particular decision. But I was just thinking, the questions that you asked in the beginning have set a train of thought in my mind. And again, I just want to circle back to this whole, the dangerous discourse of the adversarial nature, the us versus them, we the traders versus they the banks, or we the underwriters versus them the commodity traders. There's an anecdote that I wanted to share with the entire group, just before I talk about the takeaways, because there are takeaways in this case for both traders, for underwriters, and for the banks. But before I talk about what those takeaways are, I just wanted to re-emphasize this point about how we're all in the same business, actually. We're all participants in the international sale of commodities, whether we're lenders, whether we're underwriters, or whether we're independent commodity trading houses. And this takes me back to a whole different lifetime when I was a very young lawyer and in-house at one of the international trading houses. This is not a matter of public record, and so I don't want to disclose which trading house that was, but let's just say it was an agribusiness giant based out of Minnesota whose name starts with a C. That when we had structured a transaction, this was clearly a structured transaction where we were buying steel cargoes from a manufacturer of steel in Asia. And this transaction was entered into when the steel market was at an all-time high. The transaction was structured in early 2007, and the trouble began in 2008. Now, I'm conscious that some of the people in this room are fairly youthful, and they may not remember what happened in August 2008, but in August 2008, I distinctly remember we were in a meeting, we were at a retreat in Brazil, when everyone's Blackberries, because in those days everyone had Blackberries, everyone's Blackberries at about, say, 11 a.m. in Brazil started to go off. And people started leaving. There were 400 lawyers in the room. And people started leaving the room to take urgent calls and messages. And I didn't work for one of the financing businesses of that trader at that point in time, so I hadn't received anything. But when I stepped out, I learned that 2 American banks had imploded spectacularly on roughly the same day. One was Bear Stearns and the other was Lehman Brothers. And that, ladies and gentlemen, is what set off what we now call the Great Financial Crisis. Now, that led to a massive liquidity squeeze globally, and it caused steel prices to drop. And hence, that imperiled this structured transaction, where the trader had made prepayments to a steel manufacturer at the outset. So it would give 360 days of credit, and it would recoup that credit over the next few years by monthly shipments of steel, valued at roughly $100 million each. And this was very clearly a structured transaction. When you read the contract, you would see that there was a repayment schedule which said that on the 15th day of every single month, there will be a shipment valued at about $100 million odd that will be delivered by the seller to the buyer, which had been prepaid for by the buyer. Now, bear in mind that the seller's obligations were secured by way of a discounted SDLC that was discounted by a certain German bank. Now, again, I don't want to name the bank, but German bank involved in trade finance. I think we can all take a wild guess. Now, as it turns out, I was the in-house lawyer for the steel trading business at this agribusiness giant that had a multitude of various. It had its grain trading business. They had a freight trading business. They had a petchems trading business, and then there was this steel and iron ore trading business as well. And the internal client came to me and they said that, look, Sumeet, we've got this $100 million payment that's due to come in on the 15th, and we don't think that the buyer is good for it. We don't think they're going to pay. And I said, okay, what's your security package? What security package do you have? And they said, well, we've got this discounted LC, and it's been discounted by a first-class international bank in Singapore. To which my next question was, do you have compliant documents, and can you go out and submit those compliant documents to the bank? Because it was in the nature of a payment guarantee. My apologies. It wasn't the nature of an LC discounting, but it's in the nature of payment guarantee as trade credit support issued by this bank. And there was a set of documents you had to submit under it, and the set of documents was simply a demand for payment. So obviously you could submit compliant documents. And I said to the traders, I said, okay, it's $100, a lot of money at that point in time, kind of life and death situation for the trading companies because their margins are so razor thin. And I said, hey, you know what? This is where the chips fall. As long as you can submit compliant documents to the bank's on the hook, and you should just submit those documents and get your money, which is what we did. And we got the money in to great fanfare, and the trader was made whole. But what really made an impression with me was, and the client was really happy. The internal client was very happy and said, thank you for your advice. Thank you for staying cool under so much pressure. And we've got the money in and so on. And as I was about to pop a cork or a bottle of champagne, the global funding manager of that international commodity trader visited my office. Now, this gentleman was responsible for that trader's global banking relationships. So every single bank that lent to this trader or secured any of this trader's obligations, this was the man that managed those relationships. So you can imagine this Cambridge educated member of the Pakistani aristocracy, incredibly intimidating individual, walks into my office and says, "Young man, I've heard that you made a decision yesterday where we submitted complying documents to one particular bank, and we've claimed a payment of $100 million from them, knowing full well that the primary obligor to the bank, which was the buyer, the manufacturer of that steel, will not be able to pay the bank. We know that they're about to go insolvent." And I said, "Yes, but my obligations don't lie with the bank. My obligations lie with my employer, the trader." And I gave them the best legal advice that they needed. And this gentleman said something to me which has stuck with me for many, many years. He said, "Sumeet, do you know how much that bank lends us every year?" And I said, "Actually, you know what? I don't. I don't know how much they lend us." And he said, "We have a $3 billion revolver with this particular bank. And you've now endangered that relationship for $100. Did you not think this through?" And I remember feeling ashamed of that short-sighted decision that I had taken. And he said to me, and bless this gentleman, he's, at that point in time, he was 20 years my senior. He's very calm and very polite about this. And he said that, "Sumeet, you have to understand that these people are our friends. They are our colleagues in the industry. Yes, we could have submitted complying documents. We were never in danger. We always had those complying documents. But what stopped you from telling the trader, someone needs to go across to the bank right now and tell them, look, we're submitting these documents. They are compliant. We'll be bound to pay. But you need to know that we have information that your obligor is now going to go out of business and you'll be left without recourse. And you can rely on us to do whatever we can to assist you in recovering money. So there are claims that you want us to assign. If there's intelligence you want us to provide you, if there's you're not skilled in the art of enforcing claims, we will assist you. But with great apologies, we must submit these documents to you and you must pay us." He said to me, "Sumeet, you don't have the decency to have that conversation, and you have alienated one of our friends that provides us the liquidity that we need to trade every day." So again, this made a huge impression on me and underlined the message, and I hope this message comes across today, that we're all participants in the same industry, and taking these adversarial positions serves no one. It only damages our industry as a whole. Now, this is a rather counterintuitive lesson for a disputes resolution lawyer to be giving to an audience. After all, we make our money from disputes, and disputes tend to be fairly lucrative for our business. But then, ladies and gentlemen, when our clients do well, we do well. And so there's no point in encouraging a reductive and adversarial discourse amongst our clients and the suppliers of their credit and the underwriters of their risk. That serves nobody. Obviously, if there is a genuine dispute, we're more than happy to assist. But we're not in the business of manufacturing disputes and solving relationships between our clients and their counterparties. So again, if there's a big takeaway from this, for this entire audience, it is that we're all in the same boat. And I'd like us to appreciate this judgment in that context. Let's not look at this judgment as, oh, this is a case where the bank lost and where the commodity trader clearly prevailed. And so the commodity traders are in the right. No, that's silly. Let's not do that. Let's talk about the real lessons that we can draw from this. And let me talk about the lessons that perhaps the prevailing party, let's flip the logic on its head. Ordinarily, if party A loses a case, you say, okay, parties that participate in the business of the losing party, these are the lessons, and you must avoid such and such situations. Let's leave that aside. There are lessons to be drawn for commodity traders from this judgment as well. And let me walk you through those. And then I will talk about the lessons that have been drawn for the lenders and the underwriters. In the meanwhile, guys, can I do a quick time check? Harry, how much time do we have left on the schedule? 25 minutes? Okay. I want to leave some space for questions. And so, Alankruti, have you got any questions in as yet?
We have 2 questions.
We have 2 questions, just 2 questions. Come on, guys, you can do a lot better than that. Send your questions in. You've got an opportunity to get some free legal advice from the Brain Trust at WFW. I strongly recommend that you try and take advantage of that. So what are the lessons that parties draw from this entire situation. One is, I do want to emphasize this, and this is really, really important for the traders. I know that the traders, there have been a number of corks that have been popped in this city and in London and in New York in the aftermath of this decision at the offices of the international commodity traders. But I want to caution the commodity traders. This case does not confer upon commodity traders carte blanche to enter into structured transactions, safe in the knowledge that those transactions will be honored. This case is very fact specific, and certainly I would caution against treating this case as blanket permission to go out and enter into any manner of structured transactions without consulting with your lenders and your underwriters. The case is nuanced, the case is fact specific, and if you'd like a deeper understanding of what the facts were and what the analysis was, we're at your service. So that's the first lesson. The other lesson is in relation to the duty of disclosure regarding circularity. Now, look, the trader won the case. Ultimately, the bank failed, right? But this was 3 years after the bank first raised a dispute with that trader. And yes, the trader would have probably gotten a favorable costs award from the court, but the fact is that the trader had to litigate this matter for 3 long years, spend money on lawyers, spend management time dealing with a massive dispute that was very, very public and very embarrassing for all of the parties involved. And until the decision came out, ultimately the trader was at the mercy of the court. And that's not a comfortable position to be in. You'd much rather avoid this situation as a trader by simply ensuring that when you enter into a structured trade finance transaction that is either underwritten by an underwriter or financed by a bank, you engage in frank and fair disclosure with that underwriter or with the bank. Now, this reminds me of a case that I was personally involved in when I was at a major commodity trading house in Singapore. The case is now a matter of public record and has been decided by the Paris Commercial Court, initially at trial and then on appeal, and it involves Bank BIA, that was a discounting bank on a structured LC. And so this was, those of you that are familiar with structured transactions, this was a bank funding structure in which a Middle Eastern bank required funding from Noble. It was given that funding on the back of a letter of credit issued by the Middle Eastern bank, which was then discounted by Bank BIA. Now, in the discounting facility agreement entered into between Noble and Bank BIA, it was clarified that Noble A sells the goods to Noble B. And so the buyer and the seller are related parties. This is a structured transaction. Those two statements were made. So the circular nature of the trade, well, circularity or trading amongst intercompany entities, to me, that's roughly analogous. Yeah. So it was clarified that these goods are effectively not leaving the house of Noble. It's an internal trade. And the words, "This is a structured LC transaction," was there in that. There was an indemnity in that LC facility discounting agreement, LC discounting facility agreement, where effectively the bank acknowledged that this was a structured transaction and the bank waived all of its defenses in relation to the structured nature of the transaction. Now that disclosure was the sole defense that was adopted by Noble, and ultimately the Paris Commercial Court upheld that yes, in light of this disclosure, Bank BIA cannot now belatedly complain that this was a structured transaction. So that was the sole complaint that the discounting bank had, which was that this is a structured transaction, it's not a genuine trade. One Noble Group entity is selling to another Noble Group entity. Surely that can't be a genuine trade. Surely we should be able to collect our money back from Noble. Again, the court held that, look, you, the discounting bank, underwrote the credit risk of the issuing bank. You performed due diligence on them. You were told by the trader that these goods are being sold internally within their entire company, within their global company structure. You can't now complain about the nature of the transactions. So the trader greatly assisted itself in that case by disclosing the true nature of the transaction to the discounting bank, and it left the discounting bank with no reason to complain. So I would suggest to traders that are entering into underwritten or finance, structured trade finance transactions, please disclose the circular nature of the transaction to your underwriters. I know that a number of traders are shy about this and they say that, oh, if I disclose that it's circular, I won't get funding for it, I won't get an LC for it, or I won't get a trade credit underwriter to underwrite it. I mean, again, that's a little bit short-sighted. If underwriters and banks stop underwriting and financing structured transactions, their global trade finance business will contract. They don't want that either. All they want is transparency from you, the traders, and I would encourage that sort of transparency. The global trade in structured transactions is massive, and there is a great deal of incentive on the part of the underwriters and the banks to participate in those, as long as the parties come to the table with clean hands and deal with each other in a frank and forthright manner. So on the part of the traders, I would encourage disclosure, and I would encourage a great deal of restraint in misrepresenting the true nature of the transaction. If it is a funding transaction, don't be shy with your lenders about that. Be upfront with them and let them price that risk into the transaction. It's far better to let them price that risk into the transaction at the outset than it is for you to pay lawyers to defend yourself at a later date because you weren't as forthright with your lenders as you should have been in the first instance. Invest in documentary discipline. Some of the colleagues on my team were with me many years ago. I think it was the year 2018, 19, gosh, I don't remember. There was again, this is a matter of public record. We acted for an international commodity trader, Louis Dreyfus Commodities, in a case where there was a payment guarantee issued by Euler Hermes. And in the event, LDC in that case was, if I recall correctly, dealing with Agritrade, another one of these illustrious problematic players within the commodities industry. LDC's hands, however, were perfectly clean. It had extended prepayments to Agritrade. Agritrade committed default. That Agritrade's performance was secured by a Euler Hermes bond, and LDC went into claim on that bond from Euler Hermes. And ultimately, when that claim was initially made, there were minor typographical errors on that notice of demand that was issued to Euler Hermes. And Euler Hermes then, rather disappointingly, I think, seized upon those typographical errors and said, in light of these errors, we're not going to satisfy the claim. To which we advised our clients that, look, yes, there have been some errors committed, but these are clearly errors on the face of the record. We're involved now. Our suggestion would be, instead of taking this matter to trial, let's file an application for summary judgment, because this is clearly an afterthought by Euler Hermes. They should really be on the hook for this, notwithstanding the minor errors committed by you. And the Singapore courts agreed with us. And the Singapore court said that, look, there are no tribal issues here. This case should not proceed to trial. And you, Euler Hermes, need to make payment of, I think it was something just shy of $20 million to LDC in that case. So again, invest in documentary discipline. If you need to submit complying documents, especially in a structured scenario, especially where the primary obligor to the bank or to the underwriter is distressed, make sure your documents are in perfect order. Okay, great. I have 6 minutes left and I still haven't gotten through 15 minutes. Oh gosh, okay, I'm terrible at reading. Invest in documentary discipline, okay? And a corollary to investing in documentary discipline is that you must comply to the letter with the terms of the facility agreement, the LC, or the insurance policy very strictly. Don't deviate from that. Don't give the obligor, the bank or the underwriter in this case, an opportunity to deny your claim in light of other breaches by you that are independent of the structured nature of the transaction. Because I guarantee you, if the primary obligor to the bank or the underwriter is distressed, they will have a mandate to try and avoid settling your claim. That's just business. Don't give them the opportunity to do so. Now, if you're in the position of being a bank, if you're a lender or an underwriter, my suggestion would be either make peace with structured transactions or decide you're not going to participate in them. Inevitably, if you as a lender or an underwriter don't participate in structured business, you will have to contend with the size of a business contracting, because as I have said, and as all of us in the room today know, these transactions are ubiquitous and form a massive percentage of international trade. Now, if you've decided not to participate in structured trades, make sure your documents say so. Make sure you ask these questions of your borrowers. Ask them, is this a structured transaction? Are you repossessing the goods? Are you engaging in genuine trade? Will there be actual physical shipment? Visit the facilities of your clients, lock eyes with them, sit down with them and break bread with them. And most importantly, make your expectations clear to them. Set it out in writing that we don't underwrite or we don't fund these structured trades. But again, if you're not going to fund these, you're not going to underwrite these, I think you can say goodbye to a really, really significant percentage of your business. Now, if you want to be more realistic and you do want to participate in these trades, you do want to make those millions of dollars in commissions and in premiums, then there are certain sensible precautions that you can take. One is price the circularity in. If the transaction is structured to arrange credit for a certain party and then to de-risk the lender in that party, which is the other trader, then do your due diligence on that primary obligor. Make sure that in this case, for example, in this case, the Hin Leong party, make sure that Hin Leong is going to be good for their money. If the primary risk you're running is on Hin Leong's creditworthiness, then make sure that your credit team has examined Hin Leong's credit risk appropriately and priced it accordingly. If you haven't done that, you left yourself with no recourse. Here's a controversial takeaway that I just noted down today. Avoid relying upon the underlying goods as security. Look at security packages in a holistic manner. And I know that all of the bankers and underwriters are going to be outraged at this suggestion. Hang on, Sumeet. We're financing the purchase of goods. Those goods are the only reservoir of value and the only asset. Why shouldn't we rely upon that as a part of the security package? Of course, you should rely upon that as a part of the security package. But if that's your sole recourse because you've underwritten a lemon, I wish you all the very best, because, ladies and gentlemen, you, the underwriters, and you, the banks, are not in the business of trading goods. Say you were to take custody, say in this particular case, the bank were to take custody of this HSF or high sulfur fuel oil cargo, which they said has disappeared because Hin Leong's taken the cargo, they've resold it, they've gone bankrupt. Say hypothetically, this bank, this international bank, managed to secure that cargo. What are you, the bank, going to do with that cargo? You're not a fuel oil trader. You have no expertise. You have no sales channel. What's the value of that? Bear in mind that commodities have a very strong geographical and temporal element to them. It's not like a house that you secure because you've given a mortgage, you've received a mortgage, you've lent against it, and the borrower, then the homeowner, is unable to service the mortgage, so you take custody of the home and you sell it. That's an asset that's immovable and that has a very limited temporal element. Now contrast that with a cargo of, say you were a financier for the Dole company, the Dole Fruit Company, and you've now got a Panamax of bananas waiting outside Singapore, ripening in the sun. Are you suddenly going to become a fruit trader or a grain trader and learn how to dispose of those goods overnight and secure your investment? I don't think so. Bear in mind that the underlying goods, all the title documents, the bills of lading are only a part of your security package. And ensure that in these situations, particularly where these situations are structured, you rely upon a package that's more holistic. Get guarantees and get security that you can reliably and realistically enforce on. And that actually, coincidentally, as my colleague Harry has signaled to me that we have only 10 minutes left, was the last takeaway that I had for the banks in this case, for the banks and the underwriters in this case. Alankruti, we've got 10 minutes left. I'm just wondering if we've received some questions from the audience. Perhaps I could take them now.
Yep, sure. I will. I'm going to go in order that we received them in, but the first question came in from Abhay Narkar, and we understand it to be that many players have left financing structure, many players have been left financing structured trades as they haven't had the processes in place to differentiate between structured and non-structured trades. Do you have any comments on that?
I do indeed. Now, the thing is, the structured trade finance is not a term of art. There is no globally accepted definition of what is a structured trade versus what is not a structured trade. Okay? But instinctively, my answer is that any international trade in goods that has a purpose that is ancillary to the movement of those goods, that has a purpose that is in addition to the actual trade in those goods. For example, financing should be treated as structured. Now, different industries and different companies. So we've worked with agri traders. We've also worked with traders of hard commodities that engage in these structured transactions. For example, we acted for a trader in metals cargoes that wanted to provide a risk management service to its client and therefore sold and then repurchased a cargo in order to be able to manage that risk for its client. And that's structured trade. But the policies in relation to managing the risks of that trade are very different from the policies that manage the risks that arise out of a prepayment for an agricultural cargo. So my answer to that question would be that it's not a term of art. There's no singularly accepted definition, and you will have to manage risks and develop policies that are native and peculiar to the trade that you're engaging in. Thankfully, there's a number of practitioners within this market that have dealt with these trades over many years, and you should make it a point to consult with them so that you can continue participating in these trades. I did want to acknowledge along actually this point that was made, which is that a number of parties have left the sector because they've been scared away by these circumstances that we've talked about. They've been scared away by the uncertainty and so on. To those parties, I would say there is no reason to be apprehensive about this structure, especially now that the Singapore court has clarified that these transactions aren't sham transactions. So one huge area of risk and concern has now been done away with. There's greater clarity. And I would encourage people to generate conversations around how trades can be legitimately and safely structured.
Thank you. Second question is coming from James. What are the key gaps between the case summarized today and any similar cases against underwriters?
Great question, James. The difference between cases involving lenders and the cases involving underwriters is that the cases involving lenders tend to be based upon the contractual principles that are agreed as between the parties when they strike their bargain. Cases involving underwriters are subject to the doctrine of uberema fide, i.e. a duty of utmost good faith on the part of the assured. And so there is certainly a higher duty of disclosure on the part of the assured in the event that a trade credit underwriter is underwriting these risks, as opposed to a bank on the basis of a facility agreement. And so there is that gap, and it's a significant gap, but like I said, that gap is one that can be addressed by traders as long as they adhere to their duty of disclosure and do not misrepresent the true nature of the transaction.
Thank you. So we have another question from Siva. So now that we understand and have gone through the perspective from the courts on the concept of circular trades and structured trades, how do we address the question of insurable interest in the trade, which the underwriter accuses of being circular or structured?
As it turns out, Shiva, there is case law on this, and I'm more than happy to have a discussion specifically upon insurance cases that have affected this area. Again, courts have in recent years clarified the question of insurable interest and have held again in favor of the traders that there is indeed an insurable interest in relation to either A, the underlying goods, or B, in relation to the receivables that were underwritten by the trade credit underwriters. But again, these are fairly fact-specific cases. And so again, one more quick take. I've spoken about this briefly, but again, this case and all of the other cases that have been decided in favor of the commodity traders don't provide carte blanche. And so it's very dangerous to take away from this that traders are free to structure trades in any way that they want to. That's certainly not the message we're trying to pass. But Shiva, in answer to your question, there's certainly been case law that's addressed the issue of insurable interest, and they've largely been held in favor of the assured.
So there are a couple of more questions which I feel are quite substantive, but I'll give you another from Abhay. If all parties, meaning banks and traders, are in knowledge of such complex structured transactions, and these are deemed to be regular and routine type of transactions, then why did the bank say that they're victims of fraud, therefore underwriters must pay the claim? What is your view on this line of argument?
Okay, I'm going to take this as the last question today. I'm concerned that we have only 5 minutes left, but this is a great question to close off this entire discussion. The question that Abhay has asked is that what's your view on the plea taken by the banks that they were victims of fraud? Look, let's be blunt. And again, I'm cautious about creating an adversarial discourse here. But these lenders and these underwriters at the height of the COVID crisis 2 years ago, when they were receiving billions of dollars in claims, were desperate for a solution. The desperate nature of the solution, i.e., accusing the traders of engaging in fraud, has now been uncovered by the courts, and it's been laid bare. The courts have held that those allegations, those desperate allegations that were made by lenders and underwriters, were nothing other than an attempt to defeat these legitimate claims. In fact, if there is a sham in this, the sham is the argument that there has been fraud by the traders. So I would say this: if you are an underwriter or a lender that is facing a claim of this nature, and your sole defense is that you are a victim of fraud by the commodity trader, I would strongly advise you to give up hope now. Stop expending money on your lawyers and seek advice from someone who truly understands the industry and has had real experience in this industry. There is no point in further antagonizing the source of your income, i.e. the traders. Get a second opinion, seek reliable legal advice, because, Abhay, again, thank you for the question. This plea taken by the banks and the underwriters that they were victims of fraud is entirely without basis. Ladies and gentlemen, I wanted to thank everyone that's attended the webinar today. Thank you all for taking the time to spend an evening with us. Of course, we'll be in touch with all of you personally and directly. If you have any further questions, send them to a member of our team. We will ask you for a little bit of feedback in relation to this webinar. And if you'd like us to develop on any of the matters that we discussed today, we can do so one-on-one with you, or we can do so by way of another webinar to follow this one up. But again, thank you all so much for your time. Happy holidays. And if we don't speak before the end of the year, Merry Christmas and a Happy New Year to all of you. Thank you again.